Hello, my name is Nicole Beeson. I'm a senior administrative law judge. You have an upcoming unemployment insurance hearing. Hearings may be requested by either the employer or the employee, or also someone who worked for the employer and believes that they are an employee. Employees are called UI claimants. I will now provide you with very important information you will need to know in order to prepare for your hearing. This video will cover 3 stages: what you need to know before the hearing, during the hearing, and after the hearing.
When you receive your hearing notice, review it carefully. It will tell you the time and place of the hearing, who else has been notified to appear at the hearing, the issues that will be decided, and any documents or witnesses that you must bring with you. Pay attention to the hearing date, time, and location. Do not wait until the day of the hearing to learn how to get there. Make sure you leave plenty of time for unexpected transportation delays. If you arrive late, you will not be entitled to participate in the hearing that day. Your hearing will be held by an impartial administrative law judge. The judge is independent of the Department of Labor, which made the determination being appealed. The employer and the claimant both have a right to have an attorney or other representative at the hearing, but it is not required. If you want a representative or attorney, contact one right away, giving yourself enough time to meet and prepare your case before the hearing date. If you are the claimant and would like to be represented, you may obtain a list of attorneys and representatives on the Unemployment Insurance Appeal Board website or by calling the number listed on the hearing notice. Some representatives will charge you a fee. Be aware that an attorney or non-attorney representative may only charge the claimant a fee if benefits are received as a result of the representation, and only after that fee has been approved by the appeal board. All non-attorneys must be registered with the appeal board before they can collect a fee for representing a claimant. If you have trouble speaking or understanding English, you may request an interpreter before the hearing. Call the phone number listed on the first page of the hearing notice as soon as possible to request an interpreter. If you are a UI claimant who filed a claim in a language other than English, an interpreter will automatically be provided for you at the hearing. If your hearing is scheduled to be held by telephone, the notice of hearing will have that information. Check the phone number that's listed on the notice. If it is not correct, or if an extension should be added, contact the hearing office and provide an updated number. Remember that cell phones are not as reliable as landlines and could interfere with the hearing process. For this reason, cell phones are discouraged. Before the hearing, read the notice of determination very carefully. If you are the claimant and your employer is asking for the hearing, make sure to read the employer's objection letter. Be sure you fully understand it. The facts described in these letters will be the subject of the hearing. In order to prepare yourself for the hearing, you can review your file before the hearing date. The file contains statements and documents submitted by all parties, employer, claimant, and the Department of Labor. You can review the file at the hearing location Monday through Friday between 9 a.m. and 4 p.m. You may review the file on the date of the hearing, but you should arrive at least 30 minutes early to do so. You will need the case number. It is illegal to remove anything from the file. If you're appearing by phone, you will receive a copy of the whole file in the mail.
You have a right to testify and bring witnesses to the hearing. Testimony given by witnesses who actually saw and heard the events are weighed more heavily than testimony given from somebody who heard it from somebody else. Also, testimony given by someone who actually saw and heard the events at the hearing is weighed more heavily than just a written statement. Therefore, you should make a list of witnesses and prepare well in advance for them to testify on your behalf at the hearing. Ms. Jones, are you ready to proceed?
Yes, I am.
Can you please raise your right hand? Do you swear or affirm to tell the truth? If you're unable to produce necessary evidence, either witnesses or documents or both, you may ask the administrative law judge to help you by issuing a subpoena. This will require the person holding the evidence to produce it at the hearing.
You should also collect and make copies of the documents that you believe help support your case. Bring 3 copies of any document you want the judge to consider. 1 copy is for the judge, 1 copy is for the opposing party, and 1 copy is for you.
You are required to attend all scheduled hearings. If you're unable to attend a hearing, you may request an adjournment. An adjournment is a postponement of a hearing until a later date. The judge will decide whether or not you have a good reason for your adjournment request to be granted.
As soon as you realize you need an adjournment, fax or call the hearing office. The numbers can be found on the front of the hearing notice. Make sure you explain why you need the adjournment. Whether or not you asked for a hearing, it is very important that you attend the hearing when scheduled in order to protect your rights. If you are unable to attend a hearing and the judge issues a decision unfavorable to you, you may ask to have your case reopened. The request should be made in writing to the hearing office as soon as you receive the written decision. Another hearing will be scheduled for you. At that hearing, you must explain why you could not attend the prior hearing. If the judge decides you had a good reason for not attending the earlier hearing, all the issues in the case will be reconsidered. If the judge decides that you did not have a good reason for missing the hearing, the case will not be reopened. If you fail to appear at the hearing to reopen and make another request for a hearing, the case will not be automatically scheduled. Rather, your request to reopen will be referred to the appeal board, who will grant another hearing only if good cause for failing to appear or proceed at the prior hearings is shown, or if the board determines that a hearing on the issue of good cause for failure to appear should be held. Remember, the judge will decide the case only on the evidence that has been admitted at the hearing. This evidence consists of testimony sworn under oath or affirmation and documents admitted into the record. No document in the file will be considered by the judge in reaching a decision unless the judge makes that document part of the hearing record. If you want the judge to consider a document in the file, ask specifically for that. The judge will make a decision about including the document in the hearing record. You will have a chance to tell the judge why you want the document made part of the record or why you object to any document that another party wants to make part of the record. If you review the file prior to the hearing, make a note of any document that you want to have accepted into the record and why that document is important to the case. Ahead of time, you want to write down any question you want to ask your witnesses or the other side's witnesses.
If you follow these basic steps, you'll be well prepared to present your case at the hearing.
On the date of your hearing, make sure you do the following. Arrive on time. Bring any witnesses or documents that the notice of hearing directs you to produce, and any witnesses or documents you think are important to your case. Bring the hearing notice, a writing pad, and something to write with. The claimant, the employer, and the Department of Labor are all notified of the hearing and have a right to appear and participate. Please note, all hearings will be recorded and only the judge may record the hearing.
If you're not ready to go forward with your hearing, for example, your witnesses or representatives are not present or you're missing documents, please inform the judge as soon as you enter the hearing room.
The judge will make an opening statement explaining how the hearing will proceed. When the judge finishes, he or she will ask you if you have any questions. If you do not understand anything the judge says or have other questions, this is the time to ask. The judge will tell you who will testify first and what order of witnesses will be. The judge will also order additional witnesses to wait outside the hearing room, so their testimony is not influenced by the testimony of other witnesses. All testimony is taken under oath or affirmation. Make sure you listen carefully to the judge's questions and the witnesses' answers. Take good notes during the questioning, because after the judge and any attorney or representative for the other party questions the party or a witness for the other party, you'll have the opportunity to question that person. Your notes will help you remember questions you want to ask or follow up on. If you have difficulty asking a witness a question, the judge will help you form the question you are trying to ask. The other parties will also have an opportunity to ask questions of all the witnesses as well. After all witnesses have been questioned and all evidence has been taken into the record, the judge will ask each party if they have anything further they would like to say or to present before the hearing is closed. This is your chance to summarize your case and explain to the judge why you think he or she should decide the case in your favor based on the evidence. Now that the hearing is over, you should receive the judge's decision in the mail in no more than 5 business days. Contact the hearing office if you have not received a decision. After receiving the judge's decision, read it carefully. If you disagree with it, you have a right to appeal to the Unemployment Insurance Appeal Board, but you have to file your appeal within 20 days of the date on the decision. Directions on how to file an appeal are found on the back of the decision. Make sure you read them carefully and follow the directions as provided. If you are a claimant and you are still unemployed and seeking benefits, You should continue to certify for weekly benefits as instructed by the Department of Labor. If you are the employer and need further assistance with the appeals process, you should call the Unemployment Insurance Appeal Board. The number is listed at the top of your hearing notice, or visit uiab.ny.gov. For all other employment insurance issues, employers should call the Unemployment Insurance Employer Hotline at 1-888-899-8810. If you're the claimant and need further assistance, claimants should call the Unemployment Insurance Advocate Office. Advocates on staff will further assist you by fully explaining the hearing or appeals process and answering your questions. Interpretation services are available. Call toll-free 1-855-528-5618 or by emailing uiclaimentadvocateoffice@labor.ny.gov.
This concludes my overview of how best to prepare for your hearing. For more information, please visit our website.